Good morning. It's good to be with you again. Today, I'm going to look into a crystal ball and try to predict the changes that we'll see over the next several years under the Biden administration in terms of labor law and the National Labor Relations Act. So we learned a lot about what President Biden intends to do with labor issues during his campaign, and he is making good on his promises in his past few months. First, we can expect to see many of the Obama-era policies and laws reinstated. Some of that will take time as cases make their way through the National Labor Relations Board. Some of those changes may be done more quickly through administrative actions like rulemaking or agency guidance memos, and we'll discuss some of those changes that have already happened in the first 100 days of Biden's presidency. Also, in nearly every policy area that Biden endorses, from his infrastructure plan to the Build Back Better program on COVID-19 recovery, Biden has pledged that all new federal projects will be geared toward the creation of good-paying union jobs. To do this, Biden has announced that he will appoint individuals to the labor board that will reinstate progressive pro-union labor laws and policies. So we should fully expect that to be happening in the next couple of months and years. Another way that President Biden seeks to strengthen unions is through legislation like the Protecting the Rights to Organize Act, or the PRO Act, which has already passed the House and which will fundamentally change the National Labor Relations Act. So I'll go into that in more detail in a moment. And finally, Biden has promised to specifically target the enforcement against misclassification of workers as independent contractors. He's going to be doing that through the DOL, through the EEOC, but he's also going to be doing that through changing of labor laws. So before we get started, let's lay the foundation for this topic. The National Labor Relations Act, or the NLRA, was enacted in 1935 and established the foundation of the labor laws that we still have today. It applies to all private sector, non-supervisory employees. So it's a common misconception by many employers that because you don't have a unionized workplace, that the NLRA doesn't apply to you. Unfortunately, this misconception can get employers into a lot of trouble because the truth is that the NLRA applies to both union and non-union private employers. There's a couple of exceptions with airlines and railroads, but otherwise it covers those private non-supervisory employees and employers, regardless of whether you have a union present or not. So broadly speaking, the National Labor Relations Act has several primary purposes that are probably already familiar to you. So the first is to protect employees who engage in concerted activity, including engaging in organizing efforts to form unions and collective bargaining over the terms and conditions of employment. It also prohibits employers from discriminating against employees for engaging in such protected concerted activity. And then last, it creates the Labor Board, which is responsible for enforcing the terms of the Act itself. So let's take a look at the current board, which only has 4 members right now. So typically the board is made up of 5 board members nominated by the president and confirmed by the Senate for a 5-year term. So by law, 2 of the 5 labor board members are chosen by whichever party does not occupy the White House. This means that the board will have 3 members from the current administration's party and 2 members from the other side. And it's this 1-member majority that's very critical to enacting the current administration's labor agenda on cases that are adjudicated through the National Labor Relations Board and that actually get up to the board for decision. So Laura McFerrin, she is an appointee by Obama in 2014. She is the current chairperson of the National Labor Relations Board, and she's currently the only Democrat on the board. We expected this to be changing very quickly. The other 3 members, Ring, Kaplan, and Emanuel, are all Trump appointees and are considered management side board members. Not surprisingly, we've had a lot of employer-friendly decisions coming out over the past 4 years. So Republicans currently have a 3-to-1 advantage on the board, but President Biden will have a chance to cement a Democrat majority at the board once the term of Emanuel expires in August. And also, just a couple of weeks ago, President Biden announced the newest nominee to the board, Gwen Wilcox, who is a union side attorney. Gwen Wilcox is very well respected, and she's noted for several very high-profile cases that she's brought against McDonald's for its treatment of union organizers. So she is definitely wanting to strengthen unions and organizing. The reason I'm giving you such details about the board makeup is because it has become very political and a very partisan group. And it creates huge swings in the law depending on who's in the White House. So this wasn't always the case until the 1980s. A change in the White House and the administration didn't really have much impact on the board, which maintained a fairly stable precedent in terms of case law and regulation. However, starting in the Reagan era, the Republican board upended longstanding precedent and created new laws that favored businesses, not surprisingly. The Clinton board followed suit by adopting more union-friendly labor laws, and then the pendulum swung back to the more conservative views during the Bush years, and then swung back to the left during the Obama presidency. And as predicted, the instability of labor law continued under the Trump presidency and will continue under the Biden presidency. So this is quite frustrating for employers and also for workers and unions and labor practitioners. We want stable ground, we want predictability in the law, but we are expecting some huge shifts in the next few years to come. The one other person I want to mention about the board is the general counsel. This is a very important position. It's independent. This person is independent from the board, and he or she is responsible for investigating and prosecuting unfair labor practices, as well as running elections. Also, the general counsel selects and prioritizes the type of cases that get prosecuted and eventually get decided by the board. So he or she is like the gatekeeper, really, and has the ability and the tools to shape labor law. And finally, the general counsel also issues memos about how the general counsel interprets and applies labor laws. They're not law, but it gives you an insight into the types of cases that the general counsel is trying to get to the board. So we'll take a look at a recent one that really shook things up. So President Biden has nominated Jennifer Abruzzo as the general counsel. She is a union side lawyer who has worked for many years at the NLRB, and she is currently awaiting confirmation by the Senate, which is expected to go in her favor. So let's talk about that general counsel memo that I just mentioned. This one was issued in March of this year, and it was issued by the acting general counsel, and it expresses something that isn't earth-shattering. It just says that he intends to vigorously enforce the provisions of the National Labor Relations Act, protecting employees' right to engage in concerted activity about the terms and conditions of employment. That sounds pretty standard, right? Well, what's new is that the general counsel what the general counsel considers to be a term and condition of employment. The memo specifically references employees engaging in political and social justice activities where the activities have a connection to the employee's interest as employees. And that connection will be very easily found by the board. So for example, the memo says that employees who want to join together to support the $15 minimum wage is protected. And that is even if that means that the employees are wearing buttons or hats or t-shirts that may not be consistent with your uniform policy. Another example from the memo is that employees who are protesting immigration crackdowns or making environmental objections of their employers or engaging in protests about racial justice causes, such as Black Lives Matter, will also be considered by the general counsel as, quote, inherently concerted activities, end quote. So a few years ago, a company in Portland had employees who wanted to wear buttons on their uniform that said abolish ICE. And that was to protest Trump's immigration enforcement agency. No doubt this was and is a very polarizing topic. Then the labor law was clear that employers did not have to allow the employees to wear the messaging that was purely political. And so it could require the employees to remove the buttons, especially those employees who were facing customers. But now, under this new memo, that employer may be committing an unfair labor practice if it required employees to remove those buttons. So this is a very big change. So what does this mean for you? Employers must exercise care when considering the discipline or discharge of employees who have engaged in activities related to political or social justice issues now. That's not necessarily under any law yet, but we do at least have a signal from the General Counsel of the National Labor Relations Board that these are the types of cases that this GC is going to get to the board to rule on. So next, let's talk about Biden's board's likely changes. Again, this is a bit of a crystal ball, but since we've been watching the pendulum swing back and forth through so many administrations, we have a decent path to guess on. So first, the Biden board will likely make organizing easier by allowing for smaller bargaining units, or what we call micro units. That were determined to be lawful under Obama. These units are composed of employees doing the same job at the same facility. So this allows organizing efforts to focus on smaller groups of employees. And typically, unions prefer smaller bargaining units because they're easier to organize. Now, the Trump board overturned the micro unit standard and went back to the long-standing precedent that had been around for 60 or so years. And that really focuses on the community of interest. And the purpose of that is to prevent gerrymandering of employees into smaller, separate bargaining units. So as an illustration, think about a hospital. Under the community of interest standard, all nurses would be presumptively in one bargaining unit. But under the micro unit, the ER nurses could form one union, the OR nurses could form another union, and the pediatric nurses could form yet another union. And the employer would have to manage all of those collective bargaining agreements separately. So it can be a much more arduous task for the employer and a much easier route to organizing for the union. So expect that we'll return to micro units. Second, it's likely that the Biden board will reinstate the joint employer test found under the Obama board. That standard would allow employees to assert their rights to bargain with both their direct employer and the company that contracted their services. So let me give you an example. If your company hires a janitorial service and those employees unionize, the employees may demand to bargain with their direct employer, the janitorial company, and you, the contracting company. Whoa. So the outcome will lead to increased leverage on the part of organized labor, for sure. Third, we expect to see a return of the tightening of the deadlines for union elections. And as we know, shorter deadlines generally favor unions because it doesn't give the employer much time to react and campaign against the organizing efforts. Fourth, we expect to see the Biden board return the spotlight on employee handbooks. So did you hear that for all my colleagues? Which I'll discuss in a little bit, but that means that we'll be rewriting some of your employee handbooks in the near future. Fifth, the Biden board is, in my opinion, likely to reinstate the Obama-era decision that held that if employers use their electronic email system to address or counter union organizing, then the employees must also be afforded the same rights to use the employer's email system in their organizing efforts, despite the fact that the employer clearly owns, controls, and provides the instruments. What this means is that employers will not be able to prohibit employees from using their email systems to organize. So now I'll take a look at a couple of the areas that we expect the changes to have the broadest applicability to both unionized and non-unionized workplaces, and that is handbooks. So the board has flip-flopped in how it handles facially neutral policies and employee handbooks that might, just maybe, might restrict an employee's right to engage in concerted activities. So as an example, let's say an employer maintains a policy that requires employees to treat each other with dignity and respect. We like to call these civility rules. And I'm sure that virtually every business expects this of their employees. Well, in 2004, the NLRB issued a decision called Lutheran Heritage, and it held that the mere maintenance of a neutral workplace policy like civility rules violated the National Labor Relations Act if employees could reasonably construe the rule to prohibit concerted activity, or what we call Section 7 conduct. And this was even though the rule did not explicitly reference or restrict Section 7 conduct and may have never been applied by the employer to restrict Section 7 rights. So we'll call this the old standard. Rules that required employees to act professionally or restricted abusive communication were considered per se unlawful under the old standard. The argument was that employees could reasonably construe such rules as restricting their Section 7 rights to engage in concerted activity, which can sometimes get rowdy, can get aggressive, and sometimes not so professional. This was widely criticized by employers as prohibiting them from keeping a professional, respectful, and productive and harassment-free workplace. And the Trump board did away with the old standard and applied a balancing test for facially neutral rules, and we'll call this the new standard. And it took into account, on the one hand, the nature and the extent of the rule's potential impact on an employee's Section 7 rights, and on the other hand, the employer's legitimate justification associated with that rule. So, for example, the board held that rules calling for harmonious interactions and relations, and other rules calling for employees to abide by basic standards of civility were lawful, unless they were applied in a way that was discriminatory. But the Biden board will likely return to the previous, quote unquote, old standard that if an employee could reasonably construe the rule as interfering with their Section 7 rights, then the rule is per se unlawful, and the employer has violated the National Labor Relations Act and has committed an unfair labor practice by doing so. So just as a couple of examples, here are some common examples of employee handbook rules that prohibit rude, inappropriate, or disruptive behavior. You probably have these in your handbook. Most employers do. Under current law, they are presumptively lawful. But if the Biden board reinstates the old standard, and we predict it will, then send us your employee handbooks, because we will be scrubbing them once again of basic civility rules. So next, I am going to turn to the Protecting the Right to Organize Act. So this was passed by the House in March, where there's a clear Democratic majority. The big question is, what will happen in the Senate? So given the bill is generally panned by Republicans, it will likely not survive a filibuster. And even if there was some bipartisan support for the PRO Act, if it does get passed, it will likely be a shadow of the version that passed the House. And why is that? So it's very controversial, it's sweeping, and it would, it's an understatement really to say it is an overhaul of 90 years of labor law. So I've heard multiple experts say that it's a wish list or a grab bag or everything but the kitchen sink of big labor, all wrapped up into one bill. So if you've ever heard any of the large unions saying, you know, in a perfect world, this is what labor laws would look like, that's what got put into the PRO Act, and it is sweeping. So I'm going to go through a couple of the components of the PRO Act. So as I mentioned, the PRO Act is aimed to codify union-friendly board precedent or overturn employer-friendly board precedent. So the PRO Act's provisions aim to make into law several of the cases that we've already discussed. So the PRO Act would make a finding of joint employer much easier. The PRO Act would also significantly alter the standards for determining whether an independent contractor is an employee by adopting the ABC test established by the California Department of Labor. It will also allow micro units, what we just talked about, and it will prohibit class action waivers, which are currently allowed under board law. And it will dramatically change how unions are allowed to strike, making their ability to strike much greater, and it will drastically limit what employers can do in response to unions striking. In other words, this is truly upending the labor laws that we've lived with since 1935 when the National Labor Relations Act was enacted. The PRO Act will also expedite union elections and also modify how we do collective bargaining. Just checking the time here. Good, we're good. The PRO Act would expedite elections, which would again typically result in more unions winning elections, and is widely viewed as a benefit to organizing efforts. The PRO Act would invalidate any state's right to work laws. So a right to work laws makes it unlawful for labor agreements to require an employee to join a union as a condition of employment. More than about half the states have these right to work laws on their books. Oregon, Washington, and California do not. But the PRO Act would make all of those right to work laws disappear. Another big change is that after a union wins an election, typically the employer and the union begin bargaining a first contract. The NLRB does not get involved in these negotiations unless one of the parties commits an unfair labor practice. And usually that's because one party has refused to bargain, or they're delaying bargaining, they're doing surface bargaining or regressive bargaining. Anyways, they're behaving badly. And if the unfair labor practice charge is sustained through the adjudication process, then the board will issue what's called a bargaining order. And that means it's ordering the offending party to get back to the table and bargain in good faith. Well, what the PRO Act does is it is proposing that the parties need not wait for one of the parties to commit an unfair labor practice to institute a bargaining order. So instead, as soon as the union wins an election, the employer is under a bargaining order that is automatic and immediate. And this means that if the employer violates that order, the NLRB could file a lawsuit in federal court to enforce the bargaining order. So that's a drastic change. Another drastic change in the PRO Act is its requirement of mediation and arbitration for first contracts. Again, we're talking about newly elected unions that are sitting down with the employer for the very first time to negotiate the parties' first labor agreement. And let me tell you, first agreements take time. Statistics show that the first contract usually takes about 18 months on average. So, and that can be 20, 30 bargaining sessions. They can be very timely. In fact, right now I have 3 bargaining notebooks that my computer's sitting on. They take a long time. But under the PRO Act, if the first contract is not reached in 90 days, not 180 or not 18 months, but 90 days, 3 months, a party can seek mediation. And if that mediation isn't successful within 30 days, the party can then ask for a 3-member panel to hear the party's positions. And then that 3-party panel of arbitrators will decide all aspects of the first agreement. That includes wages, benefits, work rules, scheduling, everything. And that first contract will be binding for 2 years. The PRO Act also mandates that this arbitration panel must consider the employer's financial status and prospects, the size and type of the employer's business, the employee's cost of living, the employee's ability to sustain themselves and their families, and the wages and benefits offered by competitors. So again, this is a really big change because currently, and as long as the NLRA has been around, employers aren't required to disclose their financial information to unions except in very specific situations. But under the PRO Act, if the parties cannot agree on a first contract, the employer will be required to submit their confidential financial information to the union and the arbitrators, who will review it and determine what it thinks the employer should pay employees. So to be perfectly honest, I would not expect this part of the PRO Act to survive any Senate passage of the legislation. It's too counter to everything that labor law has been over the past near century. The PRO Act also has enhanced penalties and enforcement. So the PRO Act enhances penalties that current labor laws don't have. So it proposes to grant the NLRB the ability to seek civil penalties. So currently the NLRB can only seek make-whole remedies, such as back pay for an employee who has been unlawfully discharged. The PRO Act aims to change that by including civil penalties for employers. And this is important, also personal liability for company executives. The PRO Act would also create private causes of action for violations under the NLRA. So currently, an employee who believes their employer has violated the act must file an unfair labor practice with the NLRB within 6 months of the incident. So very short statute of limitations. The NLRB is then responsible for investigating, and if sufficient evidence supports the ULP, Then the general counsel will prosecute that case to an administrative law judge who hears the evidence and makes a recommendation to the board, which makes the final decision. So typically, unfair labor practice charges are all contained within the board. So the whole thing is an administrative process. But under the new PRO Act, it proposes that after the filing of a ULP, or an unfair labor practice charge, an employee can go straight to court and seek remedies that include front pay, back pay, double damages, punitive damages, and attorney's fees. So again, a very big, drastic change. So that is all I have time for. Using and wildly speculating about the likely changes to labor laws in the next few years. But if you have any questions, I invite you to contact me. So take care, everyone. And next up is Clay Krebs. He'll be giving you an update on the new legislation that is coming around the corner. So thank you.